Well, good afternoon to you, Nzinga. Before we get to what has transpired today, perhaps it would be important to reflect on what was said, particularly on Monday, when the lawyers representing Karyn Maughan, as well as senior state prosecutor advocate Billy Downer, basically tabled their submissions before the court. The message rather centered around the fact that they were accusing the former president of basically, trying by all means necessary to silence both advocate Billy Downer as the state prosecutor in his fraud and corruption trial, as well as the legal journalist, which is Karyn Maughan, from reporting on the case that has been going on for a number of years now. So this morning we heard from the legal representatives of the former president, that's advocate Masuku as well as advocate Dalimpofu, basically telling the court that those assertions have got no grounds in terms of this particular court case. Advocate Dalimpofu even going as far as to quote the prescribed minimum sentence for a convicted person or who is convicted rather of a similar crime such as the one that the legal journalist Karyn Maughan as well as advocate Billy Downer face. That of course is the issue of breaching the NPA Act. Let me now speak to the spokesperson of the Jacob Zuma Foundation, that's Mr. Mzwanele Manyi, who's joining us now. Mr. Manyi, thank you very much for your time. Perhaps you were able to follow the proceedings on Monday, though you were not here. What do you make about of the allegations that were made inside the courtroom here, saying that this whole court process is basically about former President Jacob Zuma trying again to quote unquote delay his actual criminal matter?
Yeah, no, thank you very much for the opportunity. I think Advocate Masuku, in his first submission this morning, destroyed that nonsensical argument. Because if you just purely look at the facts, that the 20-year story that everybody's talking about, that now these so-called amicus are trying to lump onto President Zuma, that 20 years, much of it was contributed by decisions of the NPA. He pointed out that the first person to make a decision not to prosecute was Advocate Bulelani Ngcuka. The next person to also make a decision not to prosecute was another NPA prosecutor, Advocate Mje. Now, why is it that such basic factual things are being distorted by these so-called amicus? This is why they've actually exposed themselves, as Advocate Masuku pointed out, that the court cannot admit such people who are just here on red herring, who are just here to create obfuscation, because they're here making a very factually incorrect and actually lying. It's a lie to say that this is all about impeding freedom of speech. Nothing to the to that effect. There's no impediment of freedom of speech. All this case is about is a very simple thing. It's about the violation of the NPA Act, Section 41, subsection 6, which Advocate Mbofi has been clarifying. That section is very straightforward. It simply says you are not allowed to publish information without permission. That's the only issue. Only if Advocate Batoyi had said, no, I've given them permission, we wouldn't be having this case. But Advocate Batoyi is not on record giving anybody any permission. So therefore, the law has been broken. This is a very simple thing. I don't know why we're spending all this time here when the case is really an open and shut case of people that have broken the law, but they don't want to be held accountable. The law is very clear on the matter. It does not even specify what is it that you should not leak out, not you should share out. It just says any information, any document, anything. So they have shared the document, they have shared information, they have shared things without the permission of the National Director of Public Protection. That is the issue here. So everything else about media freedom and all of that is really nonsensical, it's red herring, it's obfuscation, it's people that think that they are above the law.
Mr. Manyi, we heard, of course, from Advocate Dalimpofu when he started his arguments, saying this is a very important case, and he quote unquote said he doesn't know where it will end up. Is that giving an indication of the fact that perhaps if the outcome does not favor you, you may take it up maybe to the Supreme Court of Appeal?
Advocate Mpofu was trying to point out that actually what we have here today, judiciary is on trial. This is what they say. Judiciary is on trial. Because what we have here is a case where the applicants are making an application as part of an interlocutory application before the main case. And President Zuma tried exactly the same thing. The court has pronounced on this matter, and we tried to say to the court, please, let's deal with this thing before. We lost that case in this court. We lost this case in the Supreme Court of Appeal. We lost this case in the Constitutional Court. Now today we're back here. The role players have changed. You know, what Advocate Mpofu is saying is that let's see if this justice is a justice with eyes. It's a justice that's going to say, when is President Zuma, he was told that we hear you, but raise these matters at the end of the trial. This is what President Zuma was told. Now, this court here today is busy entertaining that which the highest court of the land has pronounced on to say such matters are dealt with at the end of the trial. So based on that and that only, we shouldn't even be here. The court should have just chucked this thing out to say the highest court of the land has spoken. So we're here now listening to this thing. This whole process is actually reviewing the Constitutional Court. It's an unlawful process that's happening here. The process happening here is wrong. It undermines the authority of the Constitutional Court. Constitutional Court has pronounced it's clear on the matter. It says at the end of trial. Case closed. Why are we here now for a similar thing?
Of course, we know this is a two-way street. It's either it's going to go in your favor or against your, foundation in terms of former President Jacob Zuma. Will you appeal if it doesn't go in your favor?
If this doesn't go in our favor, it will mean one thing. It will confirm that we've got Zuma laws. And in South Africa, we will not accept a Zuma law. We've got the constitution in this country that must be adhered to by everybody, including the courts. These courts here have got no latitude to apply a Zuma law. They applied the Zuma law when they took His Excellency President Zuma to jail for 15 months. That was a Zuma law because even there, the court agreed, Constitutional Court agreed to be a court of first instance, and by so doing, by default, they prevented President Zuma, they denied President Zuma the right to appeal, they denied him the right to mitigate sentence and all of that. They denied them a right of fair hearing as contemplated in the Constitution. They applied the Zuma law. So President Zuma was incarcerated using a Zuma law. Now here we are again. We want to see if they're going to produce another Zuma law. Because when it's President Zuma that was here, they said such matters are heard at the end of the case. But here we are, dealing with the same thing. So if they say, no, if we lose the case, then it means indeed the Zuma law is confirmed and we're not going to take it lying down.
Mr. Manyi, thank you very much for your time.
You're welcome.
Okay, that's Mr. Mzwanele Manyi, who speaks on behalf of the Jacob Zuma Foundation, of course, reiterating some of the points that were made earlier on by Advocate Mpofu, who represents the former presidents in this particular matter. And of course, Zinga, I'm not sure if I'm still with you in terms of the comms, but we are expecting again proceedings to resume here at 2 o'clock. It's over to you in Johannesburg.